Imagine a scenario. It's straight out of a high-octane action movie. You've got the bad guy, he's just robbed a bank, and he's speeding toward the border in a getaway car. The police are right behind him, sirens blaring, lights flashing. He crosses the line into the neighboring country. The police cars, they just screech to a halt right at the border marker. The officers get out, watch the dust settle, and then they just, wave goodbye.
It's a classic cinematic trope, but it's also a very real legal frustration. Jurisdiction stops at the line.
Exactly. But in the movies, usually Interpol shows up or there's some cool extradition treaty. But imagine that the getaway car isn't a car, it's your personal data. And the border doesn't really exist because, well, it's the internet. If a company in one country mishandles the data of someone in another country who actually chases them down, is it that high-speed international chase? Or is it just a polite exchange of emails that goes absolutely nowhere?
Sadly, the evidence suggests it's very much the latter. And that brings us to the document we are unpacking today. It is a comprehensive report on international data protection enforcement cooperation, prepared by Dr. Helena Koslova for the European Data Protection Board, or the EDPB.
And I have to say, for a government report, this thing reads like a detective story about global jurisdiction. It's investigating this massive gap between the theory of global privacy enforcement, where we all assume these regulators are working together like a global task force, and the reality.
And the reality is what Dr. Koslova calls the soft law reality. We're going to look at why data protection authorities, or DPAs, struggle so much to work together across borders and, interestingly, what they can learn from the big siblings of regulation.
Oh, who's that?
Antitrust and Consumer Protection Agency.
It's a fascinating comparison. Basically, why can the monopoly busters share secrets, but the privacy police can't? But before we dive into all the legalese, since we are all about spreading knowledge here, I do want to give a quick shout out to our friends at www.myprivacy.blog.
A great resource.
Absolutely. If you are the kind of person who wants to stay informed on privacy rights without needing a law degree, or you just want to know what's happening with your data without wading through these 300-page legal texts, they are doing the hard work. So www.myprivacy.blog, check them out.
Staying informed is the first step in protection, for sure.
Okay, let's unpack this report. The first thing that really struck me is that the author draws this very sharp line between what happens inside Europe and what happens with the rest of the world. It feels like two different universes.
That is a crucial distinction. Within the European Economic Area, the EEA cooperation is structural. It happens daily. Under the GDPR, these authorities are practically, you could say, legally married. The French regulator talks to the German regulator. They have a shared digital system. The plumbing is there. But this report focuses on the international context cooperation between an EEA country and a non-EEA country like Canada or Japan or the US.
And that's where things get soft.
Soft law is the term used. The report, it surveys 18 different DPAs, and the results are quite telling. While there are legal tools on the books to, catch bad actors together, almost nobody is actually using them.
So what are they doing then?
They're socializing, mostly. The cooperation is limited to things like sharing best practices, attending annual conferences, maybe writing a joint open letter or scolding a tech company.
So they are pen pals. They send holiday cards and maybe a sternly worded note.
In a sense, yes. They might do awareness campaigns together. But when you look at the hard enforcement conducting joint investigations, executing search warrants for a foreign counterpart, sharing raw evidence, the survey shows almost no one is doing it outside of that European bubble.
That is honestly surprising. We hear so much about global privacy, and we have this alphabet soup of organizations, the Global Privacy Assembly, the GPA, the Global Privacy Enforcement Network, GPEN. I see their press releases all the time. Are you saying they don't actually enforce things together?
Well, they do valuable work, don't get me wrong. They help align policy, they spot trends. But the view here is that these networks are primarily forums for dialogue. They lack binding power. You can't go to a network meeting and say, I need you to raid this office in Tokyo tomorrow for my case in Berlin. It's a networking event, not a command center.
So regulators are mostly just sharing notes rather than sharing evidence? That feels like a massive loophole for global tech companies. If I'm a bad actor, I just keep moving my data shell game to where the enforcement is weakest.
It is a risk. It's called forum shopping. And if regulators aren't coordinated, it works. And the report dedicates a significant amount of time to explaining why this is happening. It's not just laziness. The obstacles are Formidable.
Okay, let's get into those obstacles, because reading this, I actually felt bad for some of these regulators. It feels like they are trying to fight a fire with one hand tied behind their back.
And sometimes both hands.
Before we list the barriers, I want to mention our other partner for this deep dive, www.comarketplace.com. We are talking about regulators needing better tools, but if you're a security professional, you need the right equipment too. You can't fight modern threats with outdated gear, and www.cisomarketplace.com helps security pros stay equipped, which is exactly what we are arguing these DPAs need to be.
Equipment is key. But for DPAs, the equipment is often legal authority. And the biggest barrier mentioned in the report is, ironically, confidentiality.
This was the part that made me laugh grimly, of course. The report essentially says that DPAs are terrified of breaking their own privacy laws.
Precisely. Think about it. To prosecute a privacy crime, you often need to share personal data complaints, specific user lists, internal logs that show who was hacked.
Right, the evidence.
But privacy laws strictly regulate how that data is shared.
Yeah.
So you have a situation where a regulator in country A cannot send the evidence of a privacy breach to country B because sending that evidence would itself be a privacy breach under country A's laws.
It's a catch-22. You can't catch the privacy violator without violating privacy.
Unless you have a very specific legal gateway, yes. And most countries just don't have that gateway built for international transfers between regulators.
And it gets even more technical. There is this concept of dual unlawfulness.
Yes, this is a major, major hurdle.
Okay, let's unpack this one. Dual unlawfulness. Sounds like a double negative or something.
It is a standard principle in international law. It means that for country A to help country B investigate something, the bad action must be illegal in both countries, and often in substantially the same way.
So if I'm investigating a company for something that is a crime here, say scraping public data, but it's just considered aggressive marketing or technically legal in your country, you can't help me.
Exactly. If the definition of harm, or even personal data, differs just slightly, the cooperation mechanism grinds to a halt. And you see this a lot because privacy laws are cultural. What Europeans consider a violation, Americans might consider standard business practice, or vice versa.
Then you add in reciprocity, the "I'll only help you if you promise you can help me later" rule.
Which seems fair, right? Quid pro quo. But the report notes that some countries legally cannot promise that. For example, Switzerland. They can only help if the other country guarantees they can return the favor. But if the requesting country's law doesn't allow them to give that binding guarantee,
The Swiss have to say no, even if they really want to help.
their hands are tied by their own statute.
And then there's just the sheer reality of resources. The report mentions some DPAs in smaller countries basically have what? A handful of people?
The resource constraints are severe. The survey found that some DPAs reported having no international department at all. 0 staff dedicated to cross-border issues. They barely have the inspectors to handle domestic complaints. So if a massive request comes in from a foreign superpower regulator asking for a complex forensic investigation, they simply don't have the manpower to execute it.
That leads to what the report calls the ultimate gap. Even if you jump through all those hoops, you share the data, you prove the crime, you get the judgment, what happens next?
Nothing. Or, often, nothing. The report highlights that there is almost no mechanism to enforce a decision abroad. You can fine a foreign company 100 million euros, but if they have no local office and no local assets in your jurisdiction, you can't make them pay. You just have a piece of paper, not a penalty.
It's a paper tiger. This is painting a bleak picture. But the report doesn't just complain, it looks for solutions. And it looks over the fence at the neighbors. Competition law or antitrust and consumer protection.
This is the real aha moment of the report. Data protection is a relatively young field in terms of global enforcement. Consumer protection and competition law have been doing this longer, and they've actually solved some of these problems.
Let's start with consumer protection. They have something called the e-consumer model.
Yes, specifically a platform called econsumer.gov, which is run by an organization called ICPE. It's a secure database where regulators share consumer complaints.
But how do they get around the privacy catch-22 we just talked about?
Yeah.
If they're sharing complaints, aren't they sharing personal data?
It is so elegantly simple. Consent. The platform relies on the user, the victim, consenting to share the data. When you file a complaint on econsumer.gov, it asks you, can we share this with international regulators to help stop this fraud? You click yes, and the legal headache just evaporates.
That is so smart. Instead of the regulator having to make a complex legal determination about confidentiality, they just ask the person who owns the data.
Exactly. It bypasses the confidentiality shield by waiving it at the source. It turns the victim into a partner in the investigation.
But the real gold standard, according to the report, is competition law, the antitrust folks.
The heavy hitters.
Right. These are the people stopping mega mergers and breaking up cartels. Why are they so much better at sharing secrets?
It comes down to leverage and incentives. Think about a merger. Two massive global companies want to merge. They need approval from regulators in the US, the EU, the UK, all over. They want that approval fast because time is money.
Right. They're desperate for a yes.
So the regulators say, look, we can speed this up, but we need to talk to each other to coordinate. Sign this waiver, allowing us to exchange your confidential business data. And the companies, they sign it. They want to cooperate.
Ah, I see the difference. In data protection, usually the regulator is chasing a company that has already done something wrong. The company has zero incentive to sign a waiver or help the process. They want to drag it out.
Precisely. DPAs rarely have that kind of leverage. However, competition authorities also have what are called second-generation agreements. These are high-level government treaties, not just agency handshakes, that specifically allow for evidence exchange and investigative assistance, like seizing documents.
So they have the full weight of the government behind them. The report also mentions this concept of comedy. There's negative comedy and positive comedy. It sounds like a personality test.
It's a diplomatic concept. Negative comedy is the polite version. It means, I will be careful not to step on your toes or interfere with your economy. It's about avoidance.
And positive comedy?
Positive comedy is active. It means, I will act on your behalf.
Oh, that's huge. Explain how that works in practice.
Imagine if the U.S. authorities could officially ask the French authorities to investigate a company in Paris because it is hurting American citizens. And under the treaty, the French authorities say, okay, we will handle this for you. We will use our laws, our police powers, and we will report back.
That effectively outsources the chase to the local cops who actually have jurisdiction.
Yes, it allocates the case to the best-placed regulator. If applied to privacy, it would solve the resource issue and the jurisdiction issue in one swoop. You don't have to fly to Paris. You just ask Paris to handle it.
So we have the blueprint. We know what works for the neighbors. What does Dr. Kaslova recommend the DPAs actually do?
The roadmap is quite detailed. It breaks down into tech, legal, and operational shifts.
Before we get to the roadmap, I just want to remind our listeners that this deep dive is brought to you by our partners. If you want to understand the policy side, check out www.myprivacy.blog. And if you're on the technical side needing the right tools, go to www.cisomarketplace.com. It's partnerships like these that let us dig through these dense reports so you don't have to.
So let's look at the solutions. First, tech. The report recommends building a secure, encrypted platform very similar to the consumer protection one, where GPAs can upload complaints, evidence, and notifications.
No more insecure emails.
No. If you're the privacy police, you cannot be sending sensitive case files over Outlook. It needs to be a dedicated, secure infrastructure with language support and access controls.
And legally. Because that seems like the hardest part.
This is the heavy lifting. The report states clearly, DPAs cannot fix this alone. Governments need to step in. We need second-generation agreements that specifically authorize data protection cooperation at a treaty level. We need to move beyond non-binding MOUs.
The report also mentioned model waivers.
Yes. Taking a page from the competition book. Creating standard templates where companies or individuals can waive confidentiality to speed up an investigation.
Why would a company sign that if they are in trouble?
Well, even if a company is being investigated, they might want a faster resolution rather than fighting 5 different regulators separately. A waiver might allow them to consolidate the investigation into one primary jurisdiction. You'd save them legal fees in the long run.
That makes sense. And operationally, what about the one guy in the basement problem?
We need dedicated units. International work cannot be something done off the side of the desk on a Friday afternoon. It requires specific expertise.
And for the smaller countries?
Resource pooling. The report suggests something like a tech SWAT team, a pool of experts that can be deployed to help smaller DPAs when a massive technical case hits their jurisdiction.
I love that idea, a traveling band of privacy experts dropping in to handle the heavy lifting.
And finally, the EDPB itself has a role. The report suggests they should issue a toolkit of legislative actions and comprehensive guidance. Basically, they need to define confidentiality in a way that stops it from becoming a shield for bad actors.
Right, because if privacy prevents privacy enforcement, the snake is eating its own tail.
Exactly. The report is a call to action to break that cycle. It is saying, stop pretending that soft law is working. It isn't. We need to harden the infrastructure.
So, to summarize where we are currently in the handshake phase of international privacy. Lots of polite meetings, lots of best practices, lots of brochures. But the report argues we have the blueprint, thanks to antitrust and consumer law, to move to the handcuff phase.
Or at least the hard enforcement phase. The tools are there. It's a matter of political will to build them.
So here's the thought I want to leave you with today. The digital economy is growing exponentially. Data crosses borders in milliseconds. If regulators don't figure out how to cross borders as fast as the data does, do national privacy laws eventually become unenforceable symbols rather than actual protections? Are we just writing speed limits for a highway where the police cars can't leave the parking lot?
That is the defining question for the next decade of data protection. If we don't solve the international piece, the domestic laws lose their teeth.
Huge thanks to Dr. Helena Kaslova for this incredible report. It's a wake-up call the industry needed. And a massive thank you to our sponsors, www.myprivacy.blog and www.cisomarketplace.com for making this deep dive possible. Check them out and keep learning.
Until next time.